We have another guest speaker in for tonight. We have a lovely Tim, who is going to be chatting to us about all things contract specific for starting off as a relatively new indie studio and developer. So again, it's obviously something that we've discussed more recently with contracts and lawful stuff. So I think it's a valuable thing to kind of be still chatting about and learning. But I'm going to hand over to the lovely Tim now to present.
Thanks, Kirsty, and thanks, Andrew, and good to be here, everyone. As Kirsty and Andrew mentioned, so also we're going to talk like legal stuff, contracts. I appreciate everyone coming out for hopefully not too boring talk on a Wednesday night, and I appreciate everyone's giving up their evening to talk contract stuff. Just a quick, it wouldn't be a legal talk without some sort of small print. So a little quick disclaimer from me. So while I'm a qualified lawyer, this isn't legal advice, it's legal education and guidance concerning the types of contracts we're going to talk about. It's also like not a definitive list of things to change during a negotiation process in respect to these contracts. I'm going to do my best to run through kind of as much as I can in the time we've got. It's still not going to be enough time to discuss everything. I could easily talk about contract stuff for several more sessions, but I'm sure that's probably going to be a bit boring, and I don't want to take up any more of your time. But if you do want some specific advice, feel free to reach out to me after the talk and ask me some specific questions. And you can find more information about me on my LinkedIn. I've written a whole bunch of articles on IP and games, publishing contracts, and kind of other fun stuff that you can find on LinkedIn or my blog at gamedeveloper.com. And these are all the sort of ways you can get in touch with me. So please feel free to add me on any of this kind of social media channels. Obviously, I'm in the Discord as well, so feel free to DM me in here if that. So a little bit about me. So I am a games lawyer. I work at Sheridan's, and I work with a kind of a mix of indie developers and publishers. If I had to kind of describe sort of what I do, I mean, games lawyer kind of gets banded around. I don't really know if that is very descriptive about what I do. I describe myself as a commercial intellectual property lawyer, so I deal with a lot of game studios that are looking to protect or enforce their IP. And I also deal with a lot of contracts that kind of come in and around the games industry. So that's obviously publishing contracts, freelancer contracts, and royalty share agreements, which we're going to discuss today. But it also, covers everything from kind of like M&A to investments and all of that as well. And that includes working with some of the studios you see here. So key contracts, what to look for. We're going to look through kind of like three of the kind of like key contracts that crop up a lot, or I see cropping up a lot, especially for indies. Kind of do like a whistle stop tour through all of them. As Kirsty and Andrew mentioned, if you've got questions, well, feel free to raise them throughout the talk if you want, or put them in the chalkboard, and I can have a little Q&A at the end. But we're going to look at publishing agreements, which obviously see a lot on. There's more indie publishers now than ever. Work for hire, contractor, freelancer stuff, however you want to call it, and those sorts of agreements. Then revenue sharing as well. That can either sit as a separate agreement in itself, or sometimes tend to be connected to work for hire, and obviously more often than not connected to publishing agreements will normally have revenue sharing terms. So we'll kind of have a little look through those as well. So just to kind of give you an idea of the flow of rights and where people are sitting in terms of like the contractual relationships. Obviously, when we're talking about the publishing agreements, that's, if you are the developer in the middle, obviously that's where your agreement with the publisher is going to be between dev and publisher, obviously. If you're engaging freelancers, obviously that tends to be between you and someone else, so not the publisher. So if you're the contributor, you normally don't have a direct contractual link through to the publisher. And that's why if you're the developer in the middle, obviously it's important that you have contracts both of these parties, because ultimately you are going to be responsible to either the contributor for certain things like paying them, and also to the publisher in terms of providing certain things to them, such as delivering builds of the game and that kind of stuff. Publishing agreements, obviously publishers, I picked a selection of kind of like indie ones here, but it feels like there's more publishers kind of like cropping up every week, which I guess is good news for indies. But more often than not, their terms are pretty crap. And there's definitely a lot of things to sort of like look out for. And publishers, they definitely have a role in terms of funding for games. They obviously play a very, very important role there. And if you're looking, obviously most people want a publishing agreement because I guess the connotation of it is it comes with a degree of financial security. But also publishers should be providing, certain other services as well, such as marketing, QA. They might be helping with porting and localization, generally helping with platform submissions and all of that. And I kind of see a lot of publishers now, especially the ones on this list here, as very much like record labels. When I was sort of like growing up like 10, 15 years ago, I would tend to listen to like music from a very specific label, so like Sub Pop or whatever. And you can kind of see that with sort of like consumers now. They will really go in for a label. I think Devolver and Chucklefish, very clear ideas of what sort of games that those two labels kind of like put out. And that's how I see sort of like publishers and what they do now. So sort of first things first, do you need a publisher? I guess it's easier, it's easier than ever to kind of like as an indie to develop it. I say it's easy, and that's coming from somebody who's not a developer. But in terms of like creating and releasing games, the whole process from development to submission to online platforms has been made easier and easier. Back in the day, it was like you actually wouldn't be able to get on the platforms unless you had a formal publisher / distributor that would help you with actually getting your game out there. Didn't have the online digital distribution that you sort of have now, obviously through Steam and any of the platforms. So you were effectively signing a deal with someone who was going to get your game into online retail store, into actual retail stores like GameStop, and all the supermarkets. And obviously that model has changed quite a bit in the last 10, 20 years. I always kind of like have this. What I always like is this checklist. People always have this idea of I need to publish. I'm after a publishing agreement. This is what I want, and I just kind of feel like these kind of like 5 bullet points are kind of like cut to the core quite quickly about okay, well, that's fine. But if you want a publisher, exactly what are they going to be doing for you? That might obviously seem a bit of a silly question. In most cases, the answer is going to be they're going to provide me money to finish my game. And normally that will be enough for a developer to want to go with a publisher, because obviously self-funding, and if you're using savings, it's obviously not an optimal position. So if signing with a publisher can help you actually release your first game or release one of your games, then normally it's going to be a really good option. What's happening to the game IP, and we'll touch on this a bit on the next slide, but are you actually having to give your game over to the publisher, whether by giving them a very broad license, or are you assigning everything sort of over to them? How much is the publisher going to cost you? So are you actually going to see any money on the back end of this? There might be a revenue share in the agreement, but if the publisher is recouping cost on top of cost on top of cost on top of cost, might not actually receive anything on the back end. So there's normally something to think about in terms of justifying that sort of arrangement, in terms of making sure that you get enough money on the front end, so at least you can actually develop and release your game. That sort of goes back to how are you getting paid and when. If you're getting paid development fees, you need to know exactly when you're going to be able to receive that money. Normally, if you're delivering builds of the game, that's going to be tied to your payment of any development fees in the publishing agreement is going to be tied to certain milestones or deliverables that you're providing to the publisher. That in itself is relatively fine, but then it's normally also tied to the publisher approving those milestones or deliverables. So you tend to have to think about, well, does the contract actually address that appropriately? Is there a clear mechanism in here that allows for the publisher to approve my deliverable? Do they have to come back to me with a certain, within a certain number of time, and actually like confirm that something's approved or provide feedback if it's not approved? If it's not, then you would definitely need some sort of mechanism in there. And that kind of goes to the when as well, because even if a deliverable or something's been approved, and that means that you can submit your invoice in respect to a particular milestone, you need to check what the payment terms in the contract are as well, because it could easily be 30 days after the receipt of your invoice. So actually that means you've still got to go another 30 days without sort of being paid. So with any time you have a publishing contract thing, it's always worth checking what the payment terms are, and actually checking your budget and checking your cash flow and seeing how much runway or burn you sort of got, and actually whether things need to be adjusted in the contract to make sure that you don't, that you can make payroll if you're either employing people or you've engaged freelancers, and just making sure that you aren't in some sort of like finance. Always termination rights, always a bit bleak when you're at the start of a relationship to think about how could I get out of it if things go wrong. But I think it's always helpful to think at the start of any sort of contractual relationship what would happen in the worst case. Now, at the start of any sort of relationship, when you're dealing with a publisher, you can be dealing with the business development person. They're always the nicest and they're always the friendliest person you'll deal with, probably. But after you've signed, you're not really going to have any kind of like contact with them again, and you'll be handed over to like production team, design team, and then it all starts getting a little bit real. So you need to sort of be able to know if you can get out of the contract if actually the publisher isn't meeting your expectations. So if they are routinely missing payments that aren't your fault, they're not providing approvals or anything on time, you would want to be able to ensure that you can terminate the contract for breach if you need to. And most publishers will also have a right to terminate for convenience. And that basically just means that they have a unilateral right to walk away from the agreement if they choose to, usually on giving notice, probably like 30 days, 60 days, something like that. That's normal, but what I would say is if they're going to have that sort of right, then there needs to be some sort of penalty or payment to you as the developer, them to just be able to walk away without consequence. So normally you would want to look at including a kill fee for that sort of stuff, purely because you're going to have probably costs and expenses that you aren't going to be able to refund. You might have paid advances to various kind of like software licenses. You might have paid money up front to various freelancers that aren't refundable. If the publisher walks away, again, you don't want to be left in a financial position, in a bad financial position. It's worth checking the agreement to make sure that certainly isn't the case. So a few other things kind of like to have a little bit of a deeper dive into these sorts of contracts. So IP rights, generally, for a publisher to actually make use of your game, you have to have specific express permission from you to actually use it. And that's kind of the general thrust of any sort of publishing agreement, really, is to make sure that the publisher gets that permission from you. And there's a few different ways that they can do it. So one, which is less common, is for them to take a full assignment of all of the IP in your game. So effectively take all of the IP rights in your game and you assign them over to the publisher. Bit of a strange relationship, because that kind of also effectively makes your development of your game kind of like a work for hire arrangement for the publisher. That might be fine in certain circumstances, especially if you're paid appropriately for that. But effectively, if there's any sort of assignment, that allows the publisher to do whatever they want with your game. And you might have a right to that assignment might only take place for a certain amount of time, or there might be certain conditions that have to be met in which you can then claw back rights to your game. But if you are ever going through any sort, if a publisher is ever asking you for any sort of assignment of IP, it's always worth kind of like treating with caution. I'm sure you guys have done some of the other talks before, and I think you might have read some of the GDC talks from Chris Reed, who's done some really kind of good stuff on sort of like contract this. In terms of like IP, it's obviously kind of everything. Intellectual property is everything that goes into your game effectively. So, copyright, which is a form of intellectual property, effectively covers everything from code to the art to the animation to the music. Anything that effectively goes into making the game, playable. And if a publisher is wanting to take an assignment of even a very small percentage, that is, quite a powerful thing. And I think people kind of get confused and think, well, if someone was taking a small share of let's just say a house or a flat, it's kind of easy to sort of like portion, show to someone, well, you own this bit of the house or flat, like say, you own this bedroom, I own this bedroom. But for IP, it's kind of impossible to do that. So co-ownership of IP does exist. It requires like definitely some certain care, because effectively if two parties are co-owning an IP, they can effectively veto each other's use of that unless there is kind of an agreement giving one party full management rights of it. So it can easily get a little bit messy if there's any assignment. And there's a publishing, there's plenty of publishing agreements going around with this sort of stuff in it. But there's one in particular, a Midlands-based publisher. On the face of it, looks fairly innocuous. They just ask for 1% of your game's IP. But actually, in reality, and from a legal point of view, that's a very, very powerful right. There's actually no way for you to get that 1% back. The consequence of that is it means that after the rest of the publishing license is finished, it means that actually you probably can't do anything with your game because they'll be able to veto whatever you do, even though they own 1%. And actually effectively shuts you down from doing any sort of sequel or any sort of spin-off that uses or where you might reuse that game IP. I think any sort of IP assignment, tread with caution. The most common way that a publisher is going to get rights from you is through an exclusive license, and that gives them the right to have the sole permission to publish your game across various platforms, terms, and territories, and that's what we're going to go into the next bullet point down now. And that exclusive license is, obviously to even exclude you as the developer, as you might expect. Because it's a license, it's normally attached to certain conditions as to what and permissions as to what is included in that license itself. So the term is obviously the length of the license in terms of time. You might see this between, normally it will be somewhere between 5 and 10 years, but I've seen licenses that go for 25. I've seen licenses that effectively go forever. And I think the last Raw Fury contract that they made available sometime in December last year, if I'm remembering correctly, effectively that is a license that continues forever. So there's no way for you to actually, get your rights back to your game. So in a sense, exclusive license can be, just as damaging or just as restrictive as if you had assigned all of your IP over to a publisher in the first place. So it's always worth checking how long that license continues for. It might be a fixed term, it might be an initial term, and then it might automatically renew for further terms as well. Or there might be an option for the publisher to extend if the game is still generating revenues above a certain threshold. There's always lots to think about for that. Platforms also, how wide is the license they're extending? If you're just developing and delivering the PC version to the publisher, they might want to take rights to the console, and most publishers will want to do that. It's also worth asking, do they actually have plans to do anything with them? If they're going to be the party that's doing the porting, that's fine, but then obviously there needs to be something in the contract that deals with them doing the porting and actually making sure they do a good job. So normally you would want to actually have the publisher mirror any obligations that you were giving to them in terms of developing of the initial version. It just needs to be clear exactly what you're delivering. If you're only budgeted to deliver the version for Steam, then the contract needs to clearly state that. Because even if, generally when people say it's the PC version, they're also expecting a Mac and a Linux version. If you're only developing one for Windows, then it needs to be really clear. territory, so whereabouts in the world can they sell it. Most publishers are going to ask for worldwide rights, as you might expect. Generally, you'd say that is fine, but for smaller publishers, I think it's one of those things that you want to actually check marketing plan if they actually have plans to sell it in certain territories. So naturally, kind of if you think to Asia and Russia, there's kind of very specific things, or ways of selling in those territories. China, for example, obviously extremely restrictive and requires a Chinese entity to be selling in that territory. But if it's a kind of a relatively green publisher, they might not have built any of the relationships to actually be able to sell in those territories. But it's worth actually just checking with them actually what they plan to do and how they plan to kind of like break those territories and how they plan to sell in them. And if they don't have any plans, then look to carve them out from the contract itself and either do something yourself where you could self-publish in those territories, or find another partner that will actually help you publish in those territories instead. Ancillaries I've also got in this. I've got quite a lot in this bullet point. I apologise. When I say ancillaries, I mean sort of like ancillary rights, like merchandise, the soundtrack, anything else that's connected to your game that's in addition to the game itself. Again, the publishing license, it's very common for publishers to want to define the game as meaning any sort of merchandise as well, and it's quite easy to miss that. Again, and I'll refer to the Raw Fury contract quite a bit because obviously it's online and anyone can read it. But I think their definition of game, if I'm remembering correctly again, their definition of game also includes any sort of merchandise straight up. So you don't even actually, it's easy for that to sort of kind of like get glossed over. It's just as part of how they define what the game is. But if you've got, different deals with current freelancers, and we'll talk about freelance contracts in a second, but generally we tend to see that a lot of indies, and it tends to be more cost effective, particularly with composers and musicians, you might actually carve out the soundtrack rights to allow the musician or composer to sell the soundtrack through the composer's own channels, and then that allows the composer to take a cut from selling the soundtrack to the game. And normally that's done because it tends to mean that you can pay the composer musician less up front. Musician and composers like to kind of like keep that as part of their portfolio, and normally it's kind of a nice thing to do, I think, for indies. So obviously, if you've already given certain rights away, you obviously then can't give them away to the publisher. So that just needs to, if you have given things away before signing with the publisher, that just needs to be kept in check. And future games as well. What I mean by this, obviously, sequels, prequels, it might include any other additional content or DLC. Again, using the Raw Fury one as a good example. Again, how they've defined the definition of game, I'm pretty sure includes any sequels or prequels or future games. So they're actually getting more than just the game that you're delivering for them. They're also getting rights and getting their claws into any of the projects that you might make in the future. So again, if it's if the financial incentive is there and you've got a good working relationship, that actually might be okay, or you might be okay with that. In most cases, you would normally say that, well, especially when you've not really had a chance to work together by the time you're at a contract stage, a more than fair and reasonable way to actually change this is to make sure that, well, the publisher can have just dibs on any sequels and prequels. So legally that's called a right of first refusal or right of first option. So that if you do decide to develop a sequel, or they say that we want to fund a sequel, they're the first in line for you to speak to as a publisher. And rather than just giving them those rights outright, I think it's always nicer to have that sort of like middle ground that says that, well, we can have a discussion about it. You don't get them straight off the top. I think that's definitely fair, purely because when you've budgeted for this and you've submitted your budget and your list of milestones to the developer, you won't have even probably thought about the next game, and that's only going to be a decision that comes much later. So to actually kind of give the rights away to something that you've not really thought about or had a chance to think about, it just feels crazy to kind of sign that away at this stage as well. The publisher fees and expenses, I've already kind of said on the previous slide, how much does your publisher cost? So in terms of in that sense, what I'm talking about is what revenue share are they taking at the back end, and what are they taking off the top before they pay you or before they pay themselves. And normally, they're going to take off the top any sort of development fees that they're paying you. They're also probably going to deduct any sort of marketing budget or anything they put into marketing. Again, that might be fine, but if for any sort of like publisher expenses and fees, it's always worth limiting them to third-party costs, purely because you can clearly get an invoice for them. They will be able to evidence that they've received a certain invoice for, whatever money that they've spent, rather than including the publisher's own internal fees and costs as well. A lot of publishers do try and get away with that, and it's just an easy way for them to inflate their costs and make additional profit from you before you actually receive any money at the back end. So normally you'll see a definition of net receipts, net revenues, or there might be a specific list of permitted deductions that you can kind of check the line item and see what the publisher is deducting. It's always worth having a look through that as well. The delivery and approval and rejection, the final bullet point here is talking about making sure that there is a mechanical process in the agreement that requires the publisher to sign off on anything that you're providing to them, or that you're contractually required to provide to them. So if you're delivering monthly milestones and they all require the publisher's approval, it's making sure that after you've delivered those milestones, the publisher has to come back to you within, say, 5 working days. If they haven't come back to you within that time, that build should be deemed approved, or there's some sort of mechanism that allows you to get your invoice in and make sure you're paid for that deliverable. Now, that doesn't mean that the publisher can't request then bugs and fixes for it, and they may then come back with some feedback after that time. It means that you aren't going to hit cash flow issues. You can continue to kind of like develop the next build that you're then going to be required to work on. Effectively, if there's any sort of delays or approvals, then it's making sure that you aren't liable, and it's not your fault, and it's the publisher's fault, because sometimes the contract won't actually reflect that. You might be waiting for an approval that never comes. You can't then get the cash. You don't get the cash for that milestone. You're still contractually required to deliver the next milestone. You then don't have the cash to pay people. People obviously can leave the project. It can easily kind of like spiral, and then that puts you in breach of the contract, and it's obviously not your fault. So it's making sure that any sort of there is a clear process in the contract that allows you to obviously details when you're delivering any build, how the publisher is providing that approval or rejection, and when they're going to provide it. And making sure that there's clear timelines on both yourself and the publisher, so that if the publisher is at fault, everything, you aren't liable for it under the contract. So freelancer stuff to move on. I realise I'm already taking nearly at the half an hour mark, but we'll go through this as I can. The freelancer stuff, so also called work for hire, that's very much a US term, but is very much recognised over here in Europe as well. I've called them freelancer agreements, but they could be called anything. Contractor agreements, contributor agreements, all that kind of stuff, or just simple work for hire agreements. They'll obviously tend to be between a developer and their contractor, or anyone who is contributing to your game. Really, really common in the industry, but they're very easy to get wrong. And I've seen plenty of kind of like free online contractor agreements that I think are fine up to a point. But at any sort of time where if you are signing with a publisher, I think it's always worth having a formal contract in place, because it only takes one sentence to really mess the whole thing up. I've got here that these contracts should be in writing, and there's a good reason for that, and it's specifically to do with the ownership of IP that the freelancer contributor is creating. So again, I'm sorry if you guys already know this, but sort of like IP law basic real quick. So the default position of copyrights in this country is, and actually, also kind of mirrored across large parts of the EU and the US as well, is that the author or the creator of a work, so that might be the music, the audio, the art, or the code, is going to be deemed the first owner of the copyright in that work. There are certain exceptions to that rule. For example, if you're an employee, and there's a very specific carve out that says if you're employed by someone, then any IP in the work that you create while during the course of your employment belongs to your employer. There's also a separate exception for universities in some cases as well. So you'll often hear stuff like, well, I went to the University of Manchester, for example, and at that particular time, I think they may have changed the IP policy at the university. But effectively, all the IP in my dissertation is owned by the university. So if I tried to commercialise that, technically the university could stop me from doing so. But this does come up in a games context as well. For example, with the National Film and Television School has a very prominent game development, game design course, and they take all the IP from their students' games, which I think is bullshit. And I've actually written something about that before, but that's for another time. So obviously that applies to freelancers then. So if freelancers aren't part of these exceptions, and they technically hold any of the IP in the work they are creating for you, and that is the case even if you're paying them. Another cheeky little way to get around this is that if there's something in writing to the contrary that says all the IP is being assigned from the person who makes it to the person who's paying you, and that is why having a freelancer agreement in writing is so important, and making sure that you can, as the dev paying for that work, making sure you have the intellectual property in whatever they are providing for you. And that's important, especially if you're signing with a publisher, because you're going to be giving all sorts of scary things to the publisher that say, yes, I own all the IP in my game, and there's no sort of like disputes, and I haven't infringed any sort of laws around there. So if you don't have a written contract and you don't have the IP in place with certain contributors, you're automatically going to be in breach of those terms with the publisher. So you can see in that kind of like silly slide where I had the stick people at the front, you can easily see how if you don't have the you can easily see if you don't have kind of like the rights from the developer, you then can't then pass them up to the publisher. So again, what should you look for in these sorts of agreements? And I'll try and look at it from the developer side, as if you're engaging the freelancer, and also kind of the other way as well, if you're the contributor working with someone else. If you're the developer, you obviously want to ensure that you have the assignment to the IP in the work that they're creating. Most freelancers and contributors, that is fine, as long as you get paid for it. I think that's the kind of the crucial thing for both sides, is that it's probably fine for the developer, whoever's paying for that work, to have the IP in whatever you're creating. But that assignment should only be effective once the contributor has been paid. Otherwise, as a contributor, you kind of lose all your leverage in that sort of sense if you're already assigning all of the IP. Because if you haven't been paid for it, and if the assignment of IP from you to the dev is contingent on payment, that gives you that extra bit of leverage to ensure that you do get paid. Obviously, it's very easy. It can be quite easy, and I've definitely seen freelancers get screwed over because they have a bad contract. So payment. So there might be a rev share. We'll kind of come on to rev share in a bit. But in terms of the contract, it just needs to be clear exactly what you are paying or what you're being paid in these sorts of agreements. So you might just list an hourly, day rate, monthly rate, or payment on delivery, or approval of a certain asset. If you're the developer, you only want to pay once you've approved the actual asset, whatever's been delivered. But if you're the freelancer that delivers something is outside of the scope of what you've asked them to deliver, then obviously you wouldn't or shouldn't have to pay them for it. So that is obviously quite a simple mechanism. You don't want to be paying stuff that you haven't approved or isn't within the scope of work that you've agreed. But if you're the freelancer, you're going to want sort of like payment on delivery or something like that. Very unlikely to get that. But therefore, it's really crucial, similar to what we saw with the publishing agreements, it's really crucial to include a mechanism whereby payment is on approval, but the developer can't unreasonably withhold that approval, or they have to give you either kind of an approval or acceptance within a certain amount of time, or if they aren't approving something, then they should be giving you some feedback that allows you to go away, fix the things that they say are wrong with it, as long as they're within the scope of work, and then redeliver it and then go from there. You also need to think about payment terms. If you're the developer, how long do you have after you've approved something to actually make payment to the freelancer? And ditto, if you're the freelancer, you need to know how long it is until you're going to get paid. The scope of work, this might be kind of like a written specification as well. It's naturally going to tie in with the payment provisions above in terms of what is being delivered, and it's probably also going to tie in with the termination provisions as well. In each case, you're going to want to know precisely what's to be delivered, or what is, if you're the contributor, what you're delivering. And it's always worth having something in writing, whether it's in the contract, whether it's agreed over Slack, Skype, Trello, whatever. Something in writing so that there's no ambiguity as to what the scope of work is. There's no problem with having a degree of flexibility, but you just obviously need to be in constant communication to make that sort of thing work. If you're the contributor, you want to avoid what's called scope creep. So obviously, if you're agreeing a contract at the outset and you're delivering, say, 3 pieces of concept art, you don't really, obviously it can be quite easy for a developer, or for someone to say, well, we just need this, or just make this change. Actually, you end up delivering, more work than you actually are going to get paid to deliver. So having a clear scope of work stops that happening, because you can then clearly say, well, look, I'm fine to do more work or make changes, but actually I was paid to deliver 3 bits of concept art and 2 rounds of revisions or whatever. So making sure that it's clear, I think, is always fair for both sides. I've got representations, warranties and indemnities here, and again, these are things that you will also find in a publishing agreement as well. Effectively, these are like the legal promises that each party is making to the other. For the developer, you're going to want a freelancer to warrant that the work that they create is going to be of a high standard. It won't infringe anyone else's IP, that they've not copied the art, musical code, whatever they produce from someone else, and that kind of stuff. And that's really important as the developer, because, as I've mentioned before, you're going to be providing those exact same warranties up to the publisher, just making sure that the chain of liability is really clear, so that if the publisher says you're in breach, and actually that work was provided by a freelancer, you can then go to that freelancer and ask them to fix it. And the IP infringement, the IP infringement point is really, really big. And for most freelancers, you probably going to be fine giving those sorts of things, because they're presumably fairly easy to give. But you also then want the developer to warrant that they're going to comply with their terms of the agreement, carry out their obligations and do it as well, i.e. making sure that you get paid when the contract says you should get. This section can be pretty big in any agreement. So it's worth both parties sort of like checking out exactly what it says, so that you aren't signing up to any sort of legal promises that you aren't sure what they mean, or that go beyond your initial discussions like pre-contract. Termination, again, always talking about getting out of these contracts rather than entering them. But again, for both sides, if things go wrong, you want to know how you can get out of it. Might be, a simple way for most freelancer agreements is to have a probation period. So having a trial period, it might be a few weeks, it might be a month. Both sides can assess the other and terminate on a shorter notice period than normal. Nothing wrong with that, because sometimes you actually, when you start working with someone, you might think, actually, this isn't working out quite, you might figure out quite quickly that it isn't working out. It might be in the best interest of both sides for each party to go their separate ways. Having a probation period is something to think. If one party is sort of like terminating and walking away, you also need to make sure who's being paid up for when. So if you're the dev, you don't want to pay for work that's outside or not up to the spec. But if you're the freelancer, you're going to want to be paid for the work that you've delivered, with no transfer of that IP until you've been paid for it, as we mentioned. We also talked about termination for convenience in terms of publishers. Well, if you're the developer, you might want the ability to terminate mid-project as well. And this right might be mutual, and that's fine if it is. In each case, you need to think about the time frame for that termination. What's going to be, if you've got if the freelancer can walk away on, say, 24 hours notice, what impact is that going to have on your development if they quit in the middle of a project? You know, think about hiring someone else, bringing someone else in, having an interview, that kind of thing. So for both sides, you would normally expect a notice period. It might be 14 days, 21 days, 28 days, something like that. That allows each side to kind of terminate. Both sides work up to the end of that notice period and then, you know, help with the handover stuff, and then they go their separate ways. You're also going to think about breach and insolvency, or, you know, termination for non-payment if you're the freelancer, termination of non-delivery within a time frame if you're the developer. So there's always these sorts of things to think about as well. I've got non-compete at the bottom. There's kind of other things that you might think about as well, like non-solicitation or non-disparagement. Normally you would expect all of these things to be, well, non-compete is going to apply to the freelancer, but things like non-disparagement you would normally expect to apply mutually between the parties. If you're the freelancer and there's a non-compete in here, definitely in your agreement, you definitely want to check if those restrictions are going to, you know, fight after the contract's ended, and is it going to stop you actually from pursuing your livelihood? In most cases, though, things, depending on how broad they are, these restrictions might be unenforceable anyway. But, you know, in any event, if it's going to stop you from finishing a job and moving on to something else, it's unreasonable, then it's always worth calling that out at the start and trying to get it out. Royalty share agreements, like, quickly, so very similar to like agreements that we've just kind of seen between developer and publisher. A publisher's fully funding the game, and or if someone is a freelancer that's engaged quite early on and they're seen as a key member of staff, you might provide them with a revenue share from, you know, revenues from sales, from game sales, as a way to incentivize them. They should be quite specific. So there's some kind of like some examples, and I've kind of got gross versus net. So that means they should be specific in terms of where is the money that people are being paid from. If it's relating to a game, that's okay. But is the revenue coming from a specific platform? Is it coming from a specific territory? All of these things should be kind of specified. And again, I think that's one of these things that can easily go wrong as well. And I think the worst example, I say recent, but I think it was at least 10 years ago now, is hard lines. And you can find all this online. But this was a dispute between an indie called Nickel Hunt from I Fight Bears and Spilt Milk Studios, where Spilt Milk withheld revenue due to the freelancer unless he'd agreed to like a full assignment of copyright. And I think in that case there was a dispute over whether the freelancer's revenue would coming from the PC revenues only, which the freelancer had worked on, or would include the console. But generally, the downfall of the developer in that case is that they weren't able to withhold the revenues, was because I think they were trying to say that the revenue share should only be for the PC revenue. But actually, the contract itself just wasn't specific enough. So actually, the freelancer had a legitimate legal claim to the revenues for the console version as well. So getting these things quite specific is quite important, as with most contracts. And if anyone is going to be showing revenues, then it's key to know that if you're the party that's going to be paid a revenue share, you need to know who is collecting and who's going to be exporting the game, and when is that royalty share going to be payable. It might be paid immediately, or does it take time to vest? Do you have to have worked for a certain amount of time or delivered a certain amount of assets before you're entitled for that share to be vested? In any case, if you're the party that's not collecting, then you want an obligation on the other party to pay you whenever that payment is due. So it becomes similar to the publisher and freelancer agreements that we've just discussed, in terms of if you're going to be due to be paid something, making sure that you know when you're going to be paid, and making sure there's an obligation on that party to pay you when it's due. So also, what is the split? How much is each party going to get, and what's it based on? As you'll see from like the slide before, I mentioned that this gross versus net. So that obviously that is gross revenues or gross receipts, and net revenues and net receipts in terms of revenues that you're receiving. obviously gross tends to be a total amount that a publisher or developer has received, whereas net comes after specific deductions. Either is fine. You can have a contract say whatever you want it to say, as long as both parties are clear as to what, exactly what they're getting. Normally, you would expect a split to be from net revenues and for a publisher or developer to have taken certain deductions, after from the total amount of money that they've received. I'm just skimming through this because I'm sure you guys already know this, but the last sort of thing. So obligations on both sides, got to relate to payment, got to relate to delivery. If you're the freelancer, making sure that the developer, making sure they've done what they said they would do. And termination, again, always talking about getting out of these contracts. But obviously, if you're giving a revenue share away to someone and that person hasn't done what they said they would do, again, the contract needs to be quite clear that if something hasn't been delivered or certain things haven't met, then you should be able to stop, paying that revenue share if it isn't due. Again, this is where the specificity is really going to be key, because it can be quite a delicate balance, because obviously if you're a freelancer or you're being paid a revenue share, you want to make sure that you are paid it when you have achieved certain things. And as the developer who's going to be paying it, you obviously don't want to pay it if those situations haven't been met. So it's keeping a very clear line in the contract as to what has to happen, what situation has to happen, or what certain events have to happen in order for that payment to vest or to be triggered. Again, we talked about non-disparagement on the previous when we were talking about freelancer agreements, but I always think for revenue share stuff, it's always worth having some sort of non-disparagement in there if things go wrong, and things can very easily go wrong with these sorts of agreements. And normally there will be sort of a conflict whenever money's involved. And having something in there just prevents each party from bad-mouthing the other. It allows each side to walk away just kind of like with sort of clean hands without having to hear any sort of like negative sort of like PR. There's other things to consider that's not on this slide. So obviously, if you jointly own IP, then you might want to include a buyout clause. So you can buy out the IP in exchange for an ongoing percentage of future royalties. Some publishers might look at doing that with your IP. Also things to consider. That was I say whistle stop tour. We took 45 minutes. I could easily kind of like talk for longer and bore you all to death. But yeah, that's sort of the end. I'm at the end. But very much a whistle stop tour. If there's any questions, let me know.
Awesome, thank you very much. It's just going to be me clapping, but we're imagining everyone else is clapping at home. We need to sort out a Discord bot to do this, so that's awesome. Thank you very much for that.
You're very welcome. I hope it sort of made legal stuff interesting, because generally speaking, legal stuff is not interesting. It's important, but it doesn't necessarily make it interesting. Which is why, I guess I sort of do what I do. I get to take the boring stuff off of people's plates so that they can focus on making games and doing all of that.
Yeah, for sure. I think it's one of those things as well, like, you kind of go, oh, it's fine, I'll make games and it'll be great and we'll get lots of money, but it's this sort of, as I said earlier, it's kind of that thing that you don't really speak about here much of, is the more legal, important side of things, to make sure that you don't kind of get, kind of screwed over or anything like that. So
yeah, I think so. And there's a good so actually I ended up speaking to, I was at an event in Norway a couple of weeks ago called Consoles, like the largest kind of like games conference in Norway, and I met Rami Ismail for the first time, which was very nice. And I gave a sort of talk on that, and actually a lot of that talk is sort of mirrored in his latest newsletter. So he does like a newsletter called Level the Playing Field. I think it's very worth subscribing to it as a developer. But he mentions in his latest newsletter, he does say that if you've got questions on the contract, I would always say this to indies: it's always worth just like reaching out to a lawyer, whether it's myself or someone else kind of specified in the games industry. And speaking for how I work, particularly, if any indie comes to me with questions, I'm not going to charge for those, at least initially. If you've got initial questions or queries that you want asked on a specific contract, any good lawyer is going to give you a free consultation to discuss those so you can understand your options. And I think that's important. I think a lot of indies don't realise that that's a thing. They expect that they're just going to be charged right from the start. And at least in when I speak for myself and Sheridan's and my colleagues who I work with in the games team at Sheridan's, that's certainly not how we operate. So I think, and lawyers can be expensive, but I think the way to deal with it is to say that make sure you take advantage of a free consultation. If you decide you do need to go forward with the lawyer, ask up front how much it's going to cost you, and ask if they can fix the price for whatever it is so that it's within your budget. If you're negotiating, if it's a publishing agreement, for example, the way I would normally work is I don't get paid unless you get paid and the publishing contract is signed. If for whatever reason you walk away, I'm more than willing to wash my hands of it as well and chalk it up to that's sometimes what happens when we're talking with indies about contract. In most cases that doesn't happen. So I always think, just if people have questions, I think always feel free to reach out. And most lawyers are friendly, I'd like to think. Well, in the games industry anyway.
I feel for, well, at least games industry wise, anyone I've spoken to has been pretty friendly. So that goes for kind of developer side and sort of yourself over on more legal side. So awesome. Cool. Speaking of questions, we have got a few come in, whether that's just questions or clarifications. For anyone that has a question, chuck them in chalkboard and we'll get asking them. First one's from Sam, that's saying, if in the worst case scenario you needed to terminate the contract with a publisher, does it revoke things like license to IP, etc. automatically, or does it need to be made explicit in the contract itself?
Depends what the contract's saying, but it would, normally you would want something clear in the contract that makes it clear that the license is revoked. Normally, from the context, that would be clear that is what is happening, and the contract itself, which includes the licenses ending, so it shouldn't necessarily need to happen. I think with termination, in any event, the contract might also be, sneaky is the wrong word, but contracts will have stuff in that says that, well, even if the contract's terminated, these things carry on. So that might be things like, if the publisher hasn't recouped all of its costs, they might say, well, even if it's terminated, you need to pay this money back to us if you decide to go and sell the game or if you sign another publishing contract. So definitely check for things that do survive termination. In most cases, like the example that's sort of mentioned there, you wouldn't need to specify that the license ends in the way it does. But you can bet that there will be something that the publisher includes that says, well, even if you terminate, this is going to carry on. So it's always worth sort of like checking that.
Yeah, I guess I feel it's probably best just to explicitly put down exactly so there's no sort of grey area.
I love Andrew's question next.
Yeah, so Andrew's asking, what do you think of the various contract template sites like Do Contract brackets? I can guess the answer.
You know what? You might be surprised by this answer, Andrew. I think they have their place, and if you're an indie on a budget, then I think they're pretty good. They're certainly clear, certainly easy to use. My issue, in particular with Do Contract, is I've seen it been abused by the same contractor with four separate indie studios, effectively taking advantage of kind of like younger up and coming indies and using the contract and the flaws in that contract in a sense that allowed him to kind of extract money from the game on the front and the back end, so revenue share and also money up front. And I think one of the big flaws in that contract is it has very fluffy language around termination, specifically the do contract language around termination, which is very much like, if there's an issue, we'll talk about it, and we'll come to a solution. That's fine, but like in this particular case, if the contractor decides to be non-communicative or outright try and bully the indie, having fluffy language like that is not going to work, especially if there's revenue share and stuff involved, because you then can't get out of the contract. This person hasn't done what they said they would do, and you're still on the hook to pay them for a share of revenues, which clearly isn't fair. So do contract if you're initially and you're very close friends with the person, or you have a degree of trust with someone. It's not just someone that you've sort of like met online or never had an experience of working with before. I wouldn't, I'd recommend it in those very limited circumstances. If you're engaged in for your game and you've never met them, you don't have that kind of like, you've never had to work with them before, I think do contract can be quite a disaster. Yeah, it certainly has its place, but I've certainly seen it. I've certainly seen the worst case of it as well. And then even in those cases, you can go to a lawyer, and there might be nothing that we can do, and that's annoying, because it's if I know that if I'm there at the start of that kind of thing, these are the kind of things that I can call out quite easily at the start. That's why I always think, if you've got questions on something, always feel free to ask questions.
Awesome. Cool. Thank you. And I think it could be our final one from the evening. Is from James. That's asking, can you expand on non-solicitation clauses? The internet gives me multiple definitions for these. For example, one definition of a non-solicitation mentions trade secrets. Where is the split between learned skills, knowledge, experience, and trade secrets?
Very interesting. So, you've gone on PLC, the classic. Loads of lawyers use this as like a resource. So when I say non-solicitation, particularly what I'm talking about is not taking staff from someone, from someone else. So it's also called non-poaching, or non-dealing in sort of certain situations as well. But generally speaking, I think we were talking about it. Let's the slides back up. We were talking about it in the context of freelancer agreements, I think. Yeah, with the non-compete and stuff. So like a non-solicitation clause, if you are working with someone on a particular project and then they leave the project, you don't necessarily want them to come back to other people in your team and say, actually, I'm going to do my own thing now, will you come and work with me? And then they kind of like, they're able to poach or solicit those people from your team. So that's what I'm sort of like meaning in terms of like a non-solicitation. Now, they're not essential, and I think the games industry is small enough whereby if someone's being a bit of an arsehole, you can normally call them out on it. That's sort of what I was meaning in terms of non-solicitation. You won't see it in a lot of freelancer agreements. You might get it in. You're more likely to find it in publishing agreements. Actually, publishers weirdly get funny about developers kind of like growing to a certain size and then taking their staff away from them. So you're more likely to see it in that.
Cool. I guess if there are no more questions, just another massive thank you for Tim for your time tonight and obviously sharing your knowledge with us.
You're welcome.
Thank you. Obviously, feel free to reach out to Tim for questions. Like further up chalkboard is details and obviously the blog posts that you've done as well, so folk can check them out afterwards. But
yeah, thanks very much. Yeah, and if like I know I mentioned sort of like concepts around like IP in games as well. Those ones are only on my LinkedIn at the minute, but I will try and port them over to game developer because I know not everyone has LinkedIn or wants to go on LinkedIn. So We'll put them over to Game Developer at some point, so that they're kind of just free and everyone can access them. Yeah, thanks very much. And if anyone's got questions, feel free to get in touch. I'll do like a little introduce me in the introduce yourself chat. So if you want to add me or send me a private message, then feel free to.
So thank you very much. If you are new here, thank you for coming along. We kind of host these every other week, whether that be a guest speaker like we've had tonight with Tim, or just a GDC video that we voted on.